22 enrolled advocate in Jharkhand, and I've appeared for my AIB, waiting for my results. Let's see what happens. And I'm a pass out of Bharati Vidyapeeth, and I've completed my BBA LLB. And for LLM, I have intellectual property information technology, specialization in artificial intelligence. And further, I was working for Blue Ocean Global Technologies, and I left that job because of a few restraints which that company had for me while I was pursuing my masters. And further, I took a break for what do I say, 15 days, 20 days, and then I jumped into litigation very quickly. So, if I go through whatever has happened with me while I was in the litigation sector and I am in the litigation sector, so firstly, the transition from law school, where law school ends and you think कि अरे अब तो खत्म हो गया, अब तो सिर्फ मजा है. But when you enter litigation, that's the point you understand there's no money here. Okay, nobody's going to give you money here to do whatever work you are supposed to do. You'll have to do clerical work, you'll have to do lawyer work, you'll have to do order sheets printing, you'll have to go and collect CC, you'll have to do everything. Like for a court fee stamp to anything that is running in that court, in on your table or maybe in your chamber, is what you will have to do because you will be the junior. Okay, so why litigation and why not something else is something which I'll keep for later, and I'll be open to questions at any time, but please raise your hand so that we don't have a chaos commotion situation here. And I'll try to make it an interactive one, but an advocate can never be interactive, so you should understand that. So that is why please raise your hands whenever you have to say something or ask something. And mid-session questions, if you're not very confident about speaking, just put it on the chat box. I'll see it from there. Okay. So the transition journey, when we see that we are nearing to the end of our law school, so many of you here will be nearing to the end, and you have made your decision. Like until now, we make our decisions. Ki kya karna hai? Do you want to get into litigation? Do you want to go into the corporate structure? Do you want to take up JMFC examinations? So whatever you will be doing, my particular advice to you will be that whatever you've decided on now, take up litigation for at least a period of maybe 6 months or 7 months, on whichever state you're enrolled in. Get your enrollment first, obviously, and then begin to practice, because what you will be learning here is what you will be practicing all your life, but through a different window. Like for suppose you get into the corporate structure, and then you begin to work about what contracts, maybe a small thing like a bail application, which now you think, "Arey, kitna chota sa thing is this? Is very small. We'll make a bail application, we'll get the grounds, and it'll be done." But it's not that easy when you come into here and when you speak in front of your esteemed panel of judges, and when you speak to them why the person should be released, you're basically begging for the person to not get into custody or not get arrested or whatsoever. So these situations where you get the adrenaline, where your dopamine shoots up to the sky because you've got the person bailed out, this particular situation is nowhere but here. So what my particular point would be, when you are in a corporate structure working for someone, you understand the need of what you actually, basically you just understand ki kya, what is right at that situation for that corporate structure. So you get the people bailed out very non-connection way se. But once you're into litigation and once you're here and you have a direct contact with the client and you see how desperate they are for that one allowed word to come out of the PDJ or maybe any other judge who you are in front of, that connection gives you a different kind of dopamine or maybe adrenaline, which no other thing can give you. Like for example, even if I give you a lakh of a salary and then tell you to get bail people out, like a very small example, or maybe make a contract for them every single day, you'll do it because you're getting money out of it. But will you enjoy the whole process, or maybe will you feel any personal connection with them? You will not. This is one thing which litigation offers to you, because all the strata, everybody is there and they're coming to you, they're speaking to you, you understand what they need, what they require, and then you accordingly build the whole story around, which you call grounds in legal language. So this transition from law school to litigation is important because you realize what you actually are good at. Because I see people who are working in the corporate structure for a year, like me, and then they come back here and then they understand that this is what they wanted to do all their life, or maybe something else, or maybe this is like just a backup option for them, because until I find a good placement, I'll keep getting into the litigation structure and then understand and then get there. Because the experience which you get in litigation is versatile. Like for example, you might have matters under your you might be under your senior, so that's how you begin, because you just can't go to the court and you expect that cases aane lag jayega, because you will not get cases because you don't know anything. You don't know anything. A small clerk uh, in the court structure will know more, way more than you, will know way beyond anything, but he's not an LLB graduate, you are, but you still will realize that that person knows more than you. You will not know where an affidavit is to be done. So you know how to make an affidavit, but you don't know how to get that done. You don't know where to take the FAN to. You don't know where the person has to go and understand ki kya karna hai after whatever is done. So that thing a clerk will know. So seekhna is not a very big thing on how you have to make the affidavit, but you have to understand कि affidavit के बाद affiant जाता कहाँ पे है, how is the person rolling into the structure, how do they go to the office, how is the affidavit made. So all that litigation is going to teach you. Okay, so now the pros and the cons of both. There are pros and cons of both the structures. So the first pro in litigation is that you get a very versatile knowledge about everything, because you learn work from a stage where people are coming from scratch. They don't know anything. You have to make them, you have to explain it to them, like why did they require this particular thing, or why do they not require, why can a notice only solve the information, or maybe an informatory petition can solve their position rather a case. So you have to understand this first, and then you can explain that person the rest. So it takes a lot of in-depth education of anything, maybe anything, even if you are into a civil structure, or maybe if you are in the criminal structure. So criminal, you can't do anything, rather get into the alag procedures. I'll speak of that later. But in civil, you have way much more options than just getting a case filed and getting it into the roles of the litigation structure. So you can get into a lot of other things. So this is what you realize when you are working in the court. Outside in the corporate structure, you don't realize कि ये भी हो सकता था, we could have done this, we could have saved lot of money just by doing this. So when you go there and when you understand, like why did I not do this, rather I did this because I didn't know something like this exists. So that is what litigation will teach you. So from the bottom to the top, you will go in a very bumpy ride, but you learn everything gradually in maybe 1 year, or maybe in a span of 2 years. Because if you're a very quick learner, you will get it all in 1 year. But if you are slow with things and you take time to understand whatever is there and whatever is happening to get the hold of it, because you've never seen all this, that'll take you 2 years or maybe 2.5 years. So now if we move ahead, and if you take up the transition, now you've come to the court, you've decided you didn't get placed anywhere, कुछ government exam नहीं निकला, चलो backup में हम litigation करेंगे अब. ठीक है, you came here, you did whatever you wanted to. Okay, now you joined a senior. Now your senior is only taking up civil litigation, but has a few cases here and there of commercial or criminal or maybe family matters. Okay, so there is no lawyer here in the structure who doesn't have a variety of at least 2 types of litigations, because there'll be friends who will come up ki le le yaar mera case le le, and that will not be of the nature you peculiarly prefer. So at least 2 variants will be easily catched to you. So now you will not learn only one structure, you will learn a lot of things. So civil ho gaya, criminal ho gaya, commercial, family matters, all of these things are way in depth where you speak of, where you are behind the question and you're behind the screen, and when you're doing it through the corporate structure, you will not understand what actually happens there, and how people are fooled by the litigants, or how litigants are actually fooled by the litigators. Because it's very easy. If I tell you today that I have to file a petition for 317, you are all law students, but you still won't understand what 317 actually is. It's a miscellaneous petition where I say that the litigant cannot be present in court, so I need another date to move this forward. But now, if you are in the litigation structure and you are representing some corporate structure, and you know 17 petition is just a piece of paper which the judge is never going to read, it's just the clerk who's sitting beside the judge who's going to just mark you present. So for that, you don't have to pay 10,000 rupees. You just have to pay whatever 150, 1500, or whatever your charges are for not letting any person down who charges a lot of litigation fee. But for a simple advocate to charge 1,000 rupees for that one petition is wrong, because it's just you're just filing attendance. So your regular litigation fee is covered in that. So now when you speak of something which you'll be totally unaware of, is where you'll be caught on the wrong hand. Okay. So if you get into litigation, you understand that there are a lot of other things which you have not been taught in college, and you've not been even told about in college, and you will understand that law school is different, litigation is different. So it doesn't end once your law school ends. It will end for you if you manage to crack a good government service exam, or maybe if you are an IAS, or maybe if you're an IPS, it ends for you. Definitely, the other struggles begin. But if you get into the litigation structure, when you understand, even if you want to become a JMFC, it begins after your law school is, because that's where you understand the transition. Now, whatever was in books will come into picture in front of you. So whatever powers of the judges are, you understand once you see. Because now if I tell you that there are a few cases where the JMFC cannot bail the client out, but there are others where only the JMFC will act. So you get it, हाँ ठीक है, these are the particular cases, these are the places where I won't get the bail from this court, these are where I'll have to go to this court. So that you understand, ऐसे मतलब theoretically, these are the powers of JMFC, these are the powers of additional district judge, this is what the PDJ will do, this is what the High Court will do. But once you come there, read the bail petition, explain your grounds, ask them, only then do you understand how this actually works and what is the reason of why a JMFC cannot allow a bail on a 420 case or a 406 case in peculiar circumstances only, and why will a JMFC not allow the bail in other core criminal matters. So you have to understand, because keeping a person restrained behind for a longer period of time is not in the hands of a person who is not very well experienced or very well versed with whatever is happening around them. So that is why if you have to understand this, and when a litigator tells you that bail यहाँ से नहीं होगा, bail थोड़ा higher court से होगा, so we'll charge a little more on that, that's where you understand how reasonable the other person is. Because now if you tell me, now maybe if I leave litigation one day and join some corporate structure, and if someone tells me कि मैम ऐसा नहीं है, we'll have to take 10,000 rupees for your client's bail because we have to take it before the ADJ or maybe whatever you call it at your place. So additional district judge के यहाँ लेके जाएंगे मैम, तो इतना थोड़ा सा ज़्यादा लगेगा. But then I'll get into the thought that when I was in litigation, this particular case came to me and I got them bailed out through an JMFC. Then why is this person telling me कि ADJ के पास जाना पड़ेगा? So that rings when you are into litigation already. Okay, so now up till here, I hope you understood that this transition is difficult and you have to, take the base up. So if we move ahead, One best friend that I've been having for last 6 months is the eCode services. So that one app will teach you more than your senior will in the initial days, because that app will tell you what is your case number, where is it lying, what is the FIR detail, what is the FIR number for criminal matters. For civil matters, it will help you with this section. So at least you're prepared before you go there for your first appearance. Like, what do you have to expect? If you have not filed the case, if you have filed the case, you need to thoroughly know what has been done by you, because you are the one who is the craftsman of that particular thing. But now if you have not filed the case and the other person has, now how does this function, on knowing how do people function when they do not know what section it's pertaining to? So once a client comes to you and tells you that this is the summon I've received, this is the case number, you don't have to read the whole plaint which comes along with that, because some places the plaint doesn't even come, only the summon comes, because the plaint might have come, the client would have missed it. So that's how things work when you do not know on what sections are, what is the prayer of the particular client who's filed the case. So if the person is coming to you and they tell you that, okay, so very easy sections if I take up, which are not very difficult for a person who's in law school to understand, because that was the first section which I cracked, was 13 in Hindu Marriage Act, which is mutual divorce, where you know that the plaint has a particular structure and this is how it works. So that's where both the litigants come together, both the litigators come together, file the petition, and the work is done. But things like obtaining divorce from a cruelty structure or maybe other desertion structures, not adultery because it's no more there. So don't confuse. It's not under IPC now. So those things, if we take up and then we understand on what is to be done now, what sections does this attract with it. So there'll be other things like maintenance, there'll be other things like disposal of property. So all these things, if you take up and then you understand on where and what the structure is going to look like, is only that e-court is going to tell you, yes, these are the sections, this is what you should expect when you go to the first appearance. So there you'll know what documents to collect, because that's another thing that comes up. Because when the respondent or the defendant has to go through the litigator and collect whatever has been filed by the plaintiff or maybe the petitioner, you'll have to understand that it's not just the plain copy that you have to take. There'll be asset liability, there'll be evidence. So these things only come to you when you know that these are the sections there. Now, for example, if the litigant comes to you the day of the case, the first appearances, and then tells you, now what are you supposed to do? You can even at that point just enter the case number in the summon list that is given to you and just put in there, see whatever the matter is, and your job is done. For other criminal cases, you will have to file for an ABP, that is your anticipatory bail, because regular में जाओगे कैसे, because that person is still outside. So all those things you are ready with, because now the FIR is already done. Now you know what has to be done. Those things are different. But in cases where you actually don't know what has to be the next step, you understand e-court will teach you. Okay, e-court will tell you which particular number is which court, which judge is which in which court. The next is e-court will also help you with whatever, who is the opposite litigant or who is the opposite litigator, because you might not know. You'll obviously, in very few cases, you'll know who the opposite litigant is, or very very rare situation. But you'll obviously know, or maybe you might know someone who knows that litigator who is from the opposite structure. So, under the Advocates Act, you know that the two litigants cannot speak to each other because they are already in court. And what I have seen, that they should not speak to each other, because what happens is that this settlement becomes very difficult. Because if I tell you that, okay, I spoke to them, they said 30% mein karenge, and they come to the court and still again they have something in the mediation cell. So I'll come to that later, but a very brief of it is that you should always encourage your client to not speak to the other litigant, not because you have to earn money out of it, but because it will make your work very difficult. Okay. So now, if we move ahead, you can speak to the litigator directly, ask them that what is their intention behind filing this particular case, because at times they file for a land acquisition or maybe an eviction suit where they only require one room out of that whole house. Okay, so there, if they require only one room out of that whole house, but the land acquisition will take them 10 years, तो उससे better है you tell your client कि एक ही कमरा चाहिए, खाली कर दो. If they say कि नहीं करेंगे, then you have to take the other way around. But that's how you can solve cases in like what? Immediate basis. That will build your reputation. Because people don't like getting into the rounds कि 10 साल तक रुकना है, ऐसा क्यों करें हम. If you settle their matter in the first instance, then it's good for them and it's good for your reputation. You might not earn a lot of money out of it, but what you'll earn is a good reputation which will help you later. Okay, so now if we move ahead, in the first 5 years of your law school, how are you going to build your particular career into litigation? If anyone here who is planning for litigation, and I being a litigator will only help you guide things about litigation today, rest other topics we'll speak some other day. So if only litigation, don't think that you will take up only one structure at a time. Like when I came into litigation, I only thought I'll go for core criminal, but then when I started working, I realized that core civil is even more interesting, because you wonder why is it taking so much of time, what is actually so different in these places that takes so much time. It's not different, it's because criminal cases also do take a lot of time, but core civil cases, like a very peculiar case, like if you say title suit or maybe eviction suit, it takes a lot of time, because first you'll have to file for an eviction, then you'll have to file for a title, then you'll have to file for an execution suit. So it takes time. Now, if you analyze the stages of a civil suit, okay, very, very, very civil in nature, nothing of criminal involved, not even a inch of even raising a voice at each other is present there. It's purely civil. Okay, so you filed the suit. Okay, now the summons have to be issued to the defendant. Now understand this, that in the civil cases you'll be called plaintiff defendant or plaintiff respondent, but in other cases you'll be called the accused, maybe complainant or accused, or maybe petitioner and accused, or whatever, whichever manner. So you have to first understand this, that what are you called, what is your litigant called. If he's a plaintiff, matlab that person has filed the case, and if he's a defendant or maybe the respondent, he's the one who's to answer. Okay. Now, what one thing which is very confusing when you come down in litigation is the burden of proof lies on the plaintiff. Now, understand this. The burden of proof has to lie on the plaintiff, because that is the initiation. That's where all the dispute has come into picture. It will lie on them. Okay, I understand that. But it's not totally wrong, but it's 50% correct and 50% not correct, because it's not the sole responsibility of the plaintiff to prove what the matter is. Okay, you have to understand this as a litigator, that it is not their sole responsibility. You also have to put in equal amount of efforts, or what do you call, maybe you have to put in all that it takes to get the evidence out of your client, because it is important for you to help counter whatever evidence will come from that end. So don't think कि उसका plaintiff है तो वही देखेगा उसको क्या करना है, हमको खाली जवाब देना है. No, it's not like that. सिर्फ जवाब देने से हो जाता तो there'll be lot of cases just pending like this which are already, but the dependency of the case will only rely on the plaintiff and not on the defendant, but you still will be called the defendant. So it's not like that. Okay. Now, if we see stages in a civil suit, is where the suit is filed, then the summon is issued. Now, when the summon is issued, there'll be two things. There are two things to it. Now, how the brain of a particular litigant will work is they'll use the permutation combination which you were taught in, like, now you understand there are a few things that you still require, and you should not blame maths for all these things all the time, because you will require permutation combination all your life if you are a litigator. Now you make the combination of if the defendant appears on the first appearance, or maybe at whatever stage the case is. Okay. Now if they are appearing, two things will happen. They'll file the written statement on the next date, or they will not file. Now, see again, even the 50% ladder of that, and then again you create a 50% ladder of it. That's how your whole life will work if you're into litigation. कि अगर हुआ तो क्या, अगर नहीं हुआ तो क्या. So this is why it is very difficult to gauge your fee, because you cannot understand now if the defendant has not filed his written statement, abhi kya, because you have to argue on that statement, you have to take whatever inches have come out of it, then because the burden of proof does lie on you 50%, so you have to make your arrangements as per. Now if they have filed it, then the issues will be framed. Now what are issues? Now, when we were in law school, we used to go for moot courts, okay, where you analyze the case statement, case, whatever the facts are. Now you prepare maybe 3 to 5 questions. Okay. Now the court is going to do the same thing. They'll ask for 5 questions or 3 questions from you on why the particular suit has to be sustained, why it should be there. And those answers are given in the written statement, which is already there. So if you are a litigator, you cannot wait. If you are from the defendant side, you cannot wait कि अभी issue frame होगा तभी I'll answer the questions. No, you gauge the things first. You have to be very foresighted, and you have to understand कि ये plaint है. अच्छा चलो, let's analyze what this particular person is asking for. So now to make your thing easy, I'm revealing what secret I follow, what I was taught by my senior is read the prayer of the plaint. If you read their prayer, you will understand that these are 5 things that they require. Last point is any order under equity, justice, and natural justice, or whatever. That leaving that. If they have 2 prayers, they are asking for 2 things. So now you have to relate this particular thing with your plaint and understand what other issues can be framed apart from this. So a typical case in civil, maybe if you take up eviction suit. So first is who is the rightful owner of that particular place. It is an eviction suit, I understand, but until and unless you as a JMFC don't know who you actually have to evict, then how are you going to particularly solve that? Okay, so you have to first see who is the person who is wrongfully in retains of that particular property. So that's one question, who is the rightful owner. Second, it becomes since when are they rightful owners, and the person who's coming to maybe defense or maybe plaintiff, whoever, how long have they been staying in that particular property. So these 3 questions is, without even reading a plaint, you know that in eviction suit these 3 issues have to be framed without a doubt. If the JMFC has not framed, it's under no condition that they will not frame these 3 questions. They will frame these 3 questions, because this, without these three, you cannot go ahead. Okay, so now if these 3 questions are coming up, then you have to ask your client कि सर क्या एविडेंस है कि आप ही ओनर हैं, क्या एविडेंस है कि वो ओनर नहीं है. So if you don't have the owner list with you कि you are the rightful owner of that place, ask them what they have in confidence of the plaintiff कि वो कैसे, आपको कैसे लगता है. So you have to work both ways. You are a litigator to your litigant who is a defendant, but you have to be a litigator to your litigant through the plaintiff also. Because if you do not understand कि plaintiff क्या लेके आ सकता है, you cannot gauge your case's judgment further. Okay. So अभी मान लो issues are also framed. ठीक है, issues will only be framed if your WS is with you, like the written statement is with you. The JMFC will not be able to frame the issues if the WS is not with him or with her. Okay, now if the issues are framed, then the stage is evidence. उसके बाद कुछ नहीं है. The evidence on the plaintiff has to be recorded. Okay. Now plaintiff gave in the evidence. He gave, वो उसने सीधा घर का ही पेपर दे दिया कि लो, I am the owner, I am the rightful owner. Will the JMFC decide further ऐसे एकदम झटके से? No, that is not how things work. Now the defendant will be asked कि सर इसके पास तो rightful ownership है, अभी आपका क्या बताओ. तो देन कम्स इन द थिंग कि नहीं, इसने तो मेरे को सेल ऑफ कर दिया था, ये अग्रीमेंट ऑफ सेल है, ठीक है, ये एग्जीक्यूट नहीं हुआ है, बट दिस इज द अग्रीमेंट ऑफ सेल. और मे बी आई हैव द पावर ऑफ अटॉर्नी टू get that house down and then build something else on it. So that is another thing. So all these things, there might not be any execution on that particular document ever, and you are the wrongful owner of it, but you are a litigator. You have to understand that person has come to you. झूठा केस नहीं करना है, but you have to defend the person on getting them into a structure where they realize that not everything that they are doing is right and not everything that they are doing is wrong. So you have to protect them. Okay? Now maybe at times your litigant comes and I'm not teaching you anything that is unethical. I'm just telling you to defend the person who's coming to you. Okay. So now if the person is coming to you and telling you कि मैम ये सूट फाइल हो गया है, I am not the rightful owner of this place, I am supposed to evict this place, but I haven't found a place to stay, so I just want you to take it up to 6 months and then drop this thing down, and because until then I'll find a place to stay for myself and my children. Now tell me, in this situation, what are you supposed to do? It's just like your friend coming and telling you कि भाई मेरे को jaundice हो गया था and hence I was not able to prepare for my exam. Please help me look into 2 answers so that I pass. What are you going to do? You will obviously tell them, okay, fine, let's do this. I'll take time to file a WS or whatever other ways you have. Okay, I'm not teaching you any way today because later I don't want to be alligated on कि सिखा दिया उल्टा पुल्टा. So you will defend the person because that's how your professional ethic will work. Okay. मतलब बिना मतलब का खींचो मत उसको, जितना जल्दी हो सके टेक इट आउट, मे बी इन 3 months, मे बी इन 6 months, जो कि अगर आप राइटफुली भी जाते तो भी उससे ज्यादा टाइम लग जाएगा एनीवेज, बट उसको थोड़ा शॉर्टन कर दो सो दैट रिलीफ टू द प्लेंटिफ एज वेल एज द डिफेंडेंट इज गिवन ऑन टाइम. Okay, now if your conscience is not allowing you, then don't take it, because that's where you will not do justice to your performance. You will not be able to earn a good reputation for yourself. But at this time, you can also speak to the litigator कि sir ऐसा ऐसा बात है, this is what my client is telling me. Now what should I do? Do you want me to contest this or do you want कि थोड़ा stage को इसको let's just put it, I'm not telling you to withdraw it, but let's just put it to rest for the time being. Easy. Both of you spoke. Both of you decided. Now what is that? They'll speak to their client. Don't go to their client and tell them that अरे ऐसा ऐसा हुआ है, उनको थोड़ा टाइम चाहिए ढूंढने के लिए घर. Do you think that your client hasn't spoken to them or they haven't spoken to your client? They have, totally. Don't do that mistake ever, that you're speaking to the other litigant and telling them your client's shortcomings. That is not done because you are not doing justice to your work. Okay. Now rest. Now that the evidences have been done to your plaintiff's side also, to the defendant's side also, now the case is on argument. Okay. This is not a very crucial part. I would not say that this is a very crucial part because everybody thinks that what we actually do is take this thing up, say it in front, put it up in front of the judge, and it's done for us. No, it's not like that. The back homework is important rather the classwork. Okay. So the classwork only depends on the previous homeworks. Now, if you've not done your homework well, your today's classwork is going to be, it's actually going to go to the dogs because you will not understand from where what is going to come up. Okay. Now, if you have filed a good WS for yourself, and if you've drafted, or maybe you've drafted a good plaint for yourself, for your litigant basically, your argument will go superb. Okay. For the first half. Now, the second half of the argument is how I divide it. Like the first is where I speak of what the whole flashback story is about. Now, the second half of the argument is about what they have filed. Now, if you filed the plaint, then you will have to take up the WS. Now, if you have filed the WS, you'll have to first take up the plaint, then take your WS. So that's the two parts of the argument. Now, if you haven't done your homework well, you haven't read the WS well, what you'll do is short date दे दीजिए, नेक्स्ट डेट पे कर देंगे. ठीक है, शॉर्ट डेट भी मिल गया, नेक्स्ट डेट पे भी कर लिया, फिर भी नहीं किया, फिर भी शॉर्ट डेट दे दो, नेक्स्ट डेट पे कर लेंगे. ऐसे करके 6 महीना यू निकाल दिया. ऐसे ही मतलब 6 महीना दे दो, अभी कर लेंगे, ऐसा ऐसा कर, बाकी दूसरा काम है. ठीक है, चलो, यू गॉट द 6 महीना, यू डिड इट. स्टिल यू हैवंट डन योर रीडिंग वेल, यू हैवंट अंडरस्टूड क्या डब्ल्यूएस में लिखा था, क्या इश्यूज फ्रेम हुआ, व्हाट आर योर व्हाट इज द होल स्ट्रक्चर. Even if you have those papers in your hand, you will lose that case because you didn't do your homework well. That's where you'll get a dent in your whole reputation कि इसके आगे इसको लैंड एक्विजिशन का तो कुछ देना ही नहीं है बिकॉज इसको नहीं आता है. But you know everything. Where you lacked was you did your drafting superb, very well. It was amazing. But what you lacked is you didn't read it well. Okay. So now when I say that law school is where your enjoyment is going to end and then असली उसके बाद शुरू होता है is because you build those skills in law school. You understand reading कैसे करना है, research कैसे करना है. अभी you'll tell me that reading कैसे करना है, how do you interpret that? Reading कैसे करना है is you will have to divide your whole research paper. Maybe if you're reading a research paper and it's one page of a research paper, like it's very ideal to find a one-page research paper, but still in the ideal scenario in parallel universe you found a research paper that's of a page. Now you divide it. You read the introduction, you read the conclusion. That's how you're going to read each and every document which comes up in front of you when you're in litigation. Read the first, read the prayer, उसके बाद gauge करो अंदर क्या हुआ होगा. Because at times what you write in your plaint or what's in the complaint is totally exaggerated. It's in the very idealist of the ideal situations where you'll find that the person is blowing fists and slaps on the person and still the person didn't go and file an FIR is a very very ideal situation. It's not where the person, like if you are so much into it कि मेरे को मेरा घर वापस चाहिए ही चाहिए and the person is hitting you so bad and still you didn't get to the police station. How is that possible? You want it. It does happen in a few places where people don't take up this step and then get into the title suit eviction suit wala point. But still, why would you not do it? If you have been put to so much trauma and torture, why will you not take this step? Because you know that's how things will make your case stronger. But still you say, nahi, 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 hum nahi karenge. That's not how things work. That's a very ideal situation. It's parallel universe, to be very honest. Okay, so it's very exaggerated. So that's why you'll have to first read the intro and then the prayer or the conclusion for your research paper. And then you'll understand that this is actually what is there, this is how it began, and this is how it's going to end. So you gauge the future of that research paper immediately. So this skill is not going to come immediately to you. You'll have to read first year, second year, third year, चला गया fourth year, final year तक जाके ये gauge आता है. This foresightedness will come to you. Okay, now some people say that if you're not very good with English, if you're not refined with English, you can't argue in English. Or you definitely can argue in Hindi or your local language. And I've seen places where there are litigants who actually prefer people who know good English. Okay, that's how you impress. उतना ही काम है इंग्लिश का, उससे ज्यादा नहीं होता है. You can draft in Hindi, you can draft in your local language, you can draft in English, whatever. I don't understand why people think that सिर्फ English से ही काम बनेगा. नहीं, ऐसा नहीं है. English से काम बनेगा ऐसा. I'm not saying that दोनों language में से किसी एक में ही you should master. It's not like that. Because I had a tough time when there is a drafting in Hindi which comes in the office. Okay, it's very very difficult for me. I don't understand. Like it's very like I didn't know the word for plaintiff and respondent when I began the litigation career for myself. It is very difficult if you do not know Hindi. It's the same. Like for Hindi also, if you don't know the numbers, एक दो तीन चार के बाद में you don't know पांच को क्या होता है, what is 36 called, what is 87 called, because your number of the case is not going to be in 1 2 3 4 or maybe 1 by 2 3. So 1 by 21 22 whatever it is, it's not going to be like that. There are thousands of cases being filed and there are thousands of numbers which will come in front of you, and you'll have to say that number as 1206, maybe 1207 by 22 or whatever. So that has to come to you. That hasn't come to me yet because I still don't know further than 25. Then I know only 30, 40, 50. So it has to come to you. So now you understand it's not very important for you to know only English or maybe know only Hindi. You have to know the combination because you do not know that what the other litigator knows best. So you should know best कि आपका client safe होता है हर तरफ से. Then ठीक है. Now if you understand on what litigation you have to take up, okay, and how you're going to go forward with it is you have to read a lot. That's why I'm telling you that your research paper reading is that important. Okay, so now when you read, you understand what gives you the adrenaline, what type of papers give you adrenaline. Maybe only family matters give you the dopamine. You like to see that family drama. So don't blame yourself to not enjoy family drama because it is funny when you go to the court and then you understand. First few days you are traumatized with the situation कि क्या बोल रही है, क्या बोल रहा है, like that. But then after a few days you understand यही होता है. Take fun of it and leave it there. Don't get the baggage home because it's going to spoil your personal life. Okay, so if you see in a maintenance case which is filed by the parent on the child, you won't end up disliking your parents, na. So you have to leave that baggage there. And coming back to reading, if you read the particular starter very easily, or maybe you get the flow of it in the first read itself, doesn't mean you've mastered the skill of reading, because when you are drafting and when you get a draft to read, you will never get it at the first instance. You will not. If you're getting it at the first instance, is you are a senior advocate right away, I'll say, because you can't. It's not easy and it's not difficult. I would say it depends on what draft you're getting. Okay. So now for a typical, if we're speaking only of civil, I'll say if you've got a plaint and you've read the introduction to it, you've read the place of occurrence, date of occurrence, the sections involved, and then you straight away went to the prayer. You'll understand what masala is in that particular thing because it is masala. Okay, it's never the whole truth that is written there. If that person is putting you blows and fists, and then you also put in blows and slaps at least, और यू में भी धक्का तो मारते ही हो गया, खड़े होके थोड़ी अभी एक गाल दे दिया तो दूसरे गाल पे भी मार दिया, ऐसा नहीं होता है. इट्स वेरी आइडियल सिचुएशंस दैट कम अप लाइक दिस. तो आई डोंट अंडरस्टैंड व्हाई पीपल राइट ऑल दिस, बट ठीक है, वन डे इवन आई विल डू दैट. सो इट्स ऑल राइट. नाउ यू हैव टू रीड इट विद अ फ्लो. नो डोंट रीड इट कि ऐसे इंट्रो पढ़ लिया, अभी इधर पढ़ लिया, बीच में कुछ दिमाग ही नहीं लगाया. ऐसे नहीं होगा. यू हैव टू फर्स्ट रीड द इंट्रोडक्शन, decipher the flow, then go to the conclusion. Now right now when I'm saying this to you, it look very कि इतना टाइम लगा के एक रिसर्च पेपर करेंगे तो इतना सब है पढ़ने के लिए. ऐसा नहीं है. You have to read the first thing, then understand. उसी में तुमको समझ में आ जाएगा कि what is holding for the conclusion. Until when you are in fourth year, third year, fourth year तक समझ में आता है कि this is what is going to be there and this is what I should expect. फाइनल ईयर तक कि टाइटल पढ़ के समझ में आता है कि हाँ, व्हाट आर द फाइंडिंग्स ऑफ दिस थिंग. नाउ इफ यू रीडिंग अ थीसिस, डायरेक्टली गो टू द फाइंडिंग्स. सीधा रीड द रिसर्च ऑब्जेक्टिव्स, क्वेश्चंस पढ़ा, सीधा फाइंडिंग्स पे जाओ. रीड. नाउ यू विल अंडरस्टैंड कि what is issue and what is the finding. Now what I'm trying to say is research objectives and research questions are like the issues the judge will frame for your civil suit, and the findings in your, or maybe the conclusion, will be the judgment. It's just like that. So that's how you'll know कि you'll be in this practice of regularly updating yourself कि इतना पढ़ा है तो इसका मतलब ये हो सकता है, इतना पढ़ा है तो इसका मतलब ये हो सकता है. So you should understand that. Okay. Now This is how reading is going to help you. Now, when you're writing, okay, that's why law school focuses on research and write. It's not just researching and reading, it's also writing. Because drafting करना है ना. अभी drafting, how will you do? Without you not knowing the facts properly, without you not being able to frame the research questions, not framing the research objective, not being able to frame the thesis for your thesis. तो द हाइपोथेसिस कैसे फ्रेम करते हो, कैसे क्या करते हो, यू विल नॉट बी एबल टू राइट एनीथिंग बिकॉज you don't know what answers you're going to give. Until then you don't know what a person is actually expecting out of the paper. So what happens is you don't create a flow. That is what lacks in a few drafts which I have read all through, that it's not the language, it's the flow. If you are good with a language and still can't get the things into flow, it's no use you knowing any language. Anything on earth can stop you from getting a good draft ready for your other litigator. Okay, so if you know the language, it's not 100 out of 100, it's just maybe 10 or 20 out of 100, because you're giving a dish served to your other counterpart to help them get a flow of your language. Maybe not making grammatical errors helps the people, but even if you've made one here and there, it won't matter until your flow is right. Your litigant should understand what you've written. Your litigator, the other litigator, should understand what you're asking for. Because if you don't help put forth what actually is the problem, what actually is the redressal you're seeking, what actually is the damage you want, until then your draft is of no use, because that will help you lose the case, because you didn't know actually what to write and where to write. Okay, now, if you come back to the stages of a civil case, you will understand a few words are very different when you come into litigation. That is appearance, evidence, okay, then letter of admin. All these things are very confusing when you come to litigation. And that's where you understand that appearance का मतलब ये नहीं होता है and argument का मतलब ये नहीं होता है. So if you take the literal meaning of these words, appearance and argument, appearance is when both the litigators come with their litigants and put up the matter in front and defend a few here and there, you say a few points, and the case admits. Okay, अभी सिर्फ केस फाइल करना नहीं होता है. केस फाइल करना है, that will be allotted to whichever court to go there, get it admitted. Because without that, how are you going to do anything after this? How is the person going to file the WS? So without admission, it's not possible. Now admission हो गया, first appearance पे you will have to take all the documents. So that's how documents are important. So the IDB subject, what was it? Important documentation for business, and that subject is which comes here. That's how the role begins for documents. So documentation and reading and writing. I hope this is clear until now. And I wanted to make this interactive, but I can only hear myself speak. So if there is any doubt, please raise your hand and then I'll take up whatever you have. So moving further, in the stages in a civil suit, now what do you do if the defendant has not come? Now you think कि हाँ ठीक है हम एक्स पार्टी करा लेंगे, ऐसा हो जाएगा, मेरे तो क्लाइंट को रिलीफ मिल जाएगा. कैसे मिलेगा? The defendant has not come, they're not coming, and so you think that they'll empty that house just like that? No. If they have not come, then the problem for you begins, because ex parte kar to loge, will they obey the orders? Because this is, again, now you understand कि हर चीज ओबे नहीं करते लोग बाहर, जो कोर्ट कहते हैं उनको ओबे करने के लिए. It's not how things work. People in the court don't obey what the court tells them. तो बाहर क्या होगा? Now, if you see, if the defendant has not come at all, okay, if they have not appeared, then what do? You place an ex parte order कि the defendant is not appearing. Now, what do you do right now? Okay, अभी एविडेंस भी नहीं हो पाएगा, डिफेंडेंट कुछ भी नहीं कर पाएगा, तो क्या करेंगे अभी हम लोग? नाउ यू हैव टू समन देम अगेन. through regular post, then you go to the Nazir and the Nazir helps you send again one more thing. So that's how you need to know the clerk also, because the Nazir is the clerk to the court, okay, not to the court but the whole complex where the money has been deposited and you have to collect it from there. So that's how the Nazir works. They help send the summons through the court. So once you've done it through registered post or maybe speed post, you might as well, if court orders कि एक और बार भेज के देखो आप एड्रेस चेंज होगा, you find out that there's another address and then you again send it. ठीक है, वो भी कर दिया, वो भी रिसीव नहीं हुआ, that envelope came back the way it was. ठीक है, हो गया. Now you go to the Nazir sends that envelope also came back and again कुछ नहीं हुआ. What do you do now? Ex parte file कर दोगे सीधा? नहीं. Now you'll go to the newspaper publication. You'll ask and seek permission, prayer कि सर ऐसा ऐसा हुआ है, the person is not coming, दो particular चीजें हो गई हैं, अब क्या करें? अब चलो न्यूज़पेपर पब्लिकेशन होगा. So people think ex parte तो हम 6 महीने में करा के खत्म कर देंगे. नहीं, एक महीने का तो यही काम हो गया, तो 3 months तो ऐसे ही हो गए. नाउ यू फाइल्ड, एडमिशन हुआ, एडमिशन के बाद अपीयरेंस हुआ, 2 अपीयरेंस तक वेट करेंगे, फिर दे विल गेट इनटू द रजिस्टर्ड पोस्ट. सो एक्स पार्टी ऑर्डर्स आर आल्सो टेक टाइम. ऐसा नहीं है कि 3 महीने में हम एक्स पार्टी करा देंगे, 6 महीने में अरे सर हम तो 6 महीने में एक्स पार्टी हो जाए. नहीं, डोंट लाई टू योर क्लाइंट एवर. ओके, डोंट गिव देम फुल ट्रूथ ऑल्सो कि 1 साल लग जाएगा, तब तो कोई नहीं आएगा तुम्हारे पास. बट ऐसा भी नहीं करना है कि उसको इतना होप्स दे दिया कि वो आदमी पागल हो रहा है कि सर आपका तो हो ही नहीं पा रहा है. एंड देन बिकॉज एट दैट टाइम he is one who needs relief anyhow. Okay, so what they'll do is take the NOC from you and go to some other lawyer. That's how bad things are. Okay, so don't give them high hopes, don't keep them very low, keep them somewhere in the moderate structure where they understand what you're doing. Okay, and they don't keep questioning you कि हो क्यों नहीं रहा है, हो क्यों नहीं रहा है. But there still be other people who keep questioning you. That's where patience comes कि क्यों नहीं हो रहा, क्यों नहीं हो रहा है. Because you're giving them a service, na? You're not with them for a particular thing, and nobody likes to give money where things are not working for them. You will also not pay someone who's not helping you get the job done. Okay, so now if all these steps are over and if the court allows, you submit an ex parte petition or an application, whatever it's called at your place, that this particular defendant has not appeared after repeated summons and repeated publications which have already been made. Then it comes to the argument stage. Okay, but after evidence, obviously. So the evidence, argument and judgment remains the same in all the places, even if the defendant has not come or defendant has come. Okay? Now if you haven't submitted your like the WS, okay, you haven't filed your WS, still the thing will come down to evidence. Okay, so this is how a peculiar civil suit looks like in books. Now I'll tell you how it looks like in the whole correct framework in court. Now you come up to me, you tell me you want to file a case, whatever may be the reason for it, or if I take it up as a very small civil suit, okay, where you just have to execute your land acquisition. You got the order to your fame, like you have the decree with you, you're the decree holder, there's a judgment holder, you filed an execution. Now the decree holder submitted all the evidences with the order. Now the judgment holder, what they're going to do is they won't file anything. What they'll do is they'll keep shut, they'll keep taking dates. And mind you, people pay you so high just to, delay the order which has already been passed. It's so neatly done that you will never understand, even as a litigator, what the other litigator is doing. So experience counts here for execution suits peculiarly, but it's not very engaging or it's not very ethically right, because you're delaying someone's rights which have been conferred to them by the court. But still, so it's not idealistic, and you should always remember that you should know, even like God forbid, even if you being an advocate require help of the other advocate for your family litigation. Okay, so you don't run in the bloodline, and you need someone from the other place, because the benefit of doubt will come into picture of influence. So you will not take up their case and you're taking up someone else's case. So that's how things will work, and you will think that हाँ ऐसा ही हुआ था ना, ठीक है कोई बात नहीं, तो judgment तो मेरे ही पास है. But until you don't file for execution, what are you going to do with that judgment? It's just a piece of paper with some court fee and stamps attached to it. Okay, so expert, any expert will always guide you in a way that once you're into execution, you should be very patient, because even for an auction which has to be done and an NCLT order which has been passed has execution and appeal attached to it. Okay, so now, if we this is how we cover stages of a civil suit. Okay, it's not very difficult to understand a civil suit, but its difficulty comes up where it doesn't work the way books have showed it to you. Okay, now if we move ahead and we see, once you're into the litigation structure and then you are understanding which particular genre you have to explore. So you begin with core civil, then you come down to core criminal, and now you don't know where to go. And you think कि अरे हमको तो एक ही करना था. नहीं, it's not like that. तुम्हें एक नहीं करना है. You can take up a lot of other things also. You can take up core civil, core criminal, commercial litigation. You can take up family matters. You can take up negotiable instruments. And that is my favorite because it's so technical and it's all written in the book. You have to just go by the book. Your drafts have to be perfect here. You should know where the cause of action came up, and it's done for you. It's these cases are so, this is one particular case which I would say goes by the book until the evidence part comes up. Once the evidence has come, to tab thoda sa you'll have to raise up ki yaar abhi kya, because what evidence the other person is going to get. But the negotiable instrument is with you, so hence you are liable to pay the other person whatever amount you had given in the negotiable instrument. So it's easy that way because it's very technical. Okay, now, labor, industrial disputes, these involve a lot of welfare work. Then this also involves people from the unions, trade unions, maybe the worker union. So these are places where you have to be in touch with a lot of people here and there to understand the whole thing. Labor is not, I won't say it's difficult, or it's very peculiar and not very technical. Okay, like it's just like a civil case, just it's not just another civil case. It's very lucrative in that matter. But you'll understand once you're into industrial disputes that what actually comes up and how you actually run. Okay, now if you take up matrimonial matters, this will give you a lot of drama all your life. Then there's cyber laws, then there are other things. So you there are way much more than what you ever thought litigation can offer. There are so many things here. Okay, so now, when you see and realize that a civil case is there and these are the stages, this is what is litigation. Now, there are two other things to it, that is mediation and arbitration. What is the difference between mediation and arbitration? Mediation is where a court appointed mediator is given to you. Both the parties sit and both the parties redress कि sir ऐसा problem है, this is what I'm facing, this is what I'm facing. Now understand, these happen in civil cases, family matters, industrial disputes, matrimonial matters, anything apart from core criminal matters. Okay, now you cannot expect someone who's guilty of no, not guilty but has been accused of murder or maybe any other heinous crime to sit for mediation, speak to the other person who's not alive. So that's not possible, and that's just not idealistic to say even all these things. So it's very difficult for you to gauge कि कहाँ कहाँ मीडिएशन हो रहा है, बिकॉज सारी जगह ही मीडिएशन होता है apart from criminal. Okay, so now if you understand what particular things you need and why you're choosing the litigation and what reliefs you can get through that litigation, That's what you'll have to understand by making a roadmap for yourself. Okay. Now, when a person has come to you, then making a roadmap will be difficult. So once you are into this process and you've got maybe 6 8 months, good strong 6 8 months of practice without leave or anything, you have been in court every day without even skipping a clearance Saturday also, then that is where you can create a roadmap for yourself. First thing is that your drafting should be very on point. Okay, so now when you are in front of a very esteemed senior advocate, or maybe an esteemed good practicing advocate, then you might understand that your drafting is lacking. Okay, but if you've covered all your points, if your flow is good, if the language is good, if you've not made grammatical errors unnecessarily, then your drafting will not be something which you have to worry about. Now, if you've made big blunders like in grammar, and the whole meaning of that sentence is changed, that particular excelled advocate will catch for it. They will. Because whenever I get a draft, I try and understand what grammatical error the person is trying to make. Because that's where I'll change the meaning of that sentence, the relief will go down, and people will now understand that this person knows nothing. So that's how things work. So importance of drafting will come up when the language is good, when the flow is good, when you're using your punctuations in the right places. So this is how reading and writing, both these things have to work together. Not this These are things which go parallel to each other. They will never meet, but they go together. Okay. So now, after you know the drafting and everything, you have to now understand that you need to know the inside and out of the particular section that you're dealing with. Now, if someone comes to you, okay, and they tell you that my wife has sent me this particular legal notice, and this, because this has personally happened with me, so I'll tell you that how bad of the drafting what do you say quality, that I could not take up a particular matter for my client further. So if the person comes and tells you that this is the legal notice which I have received from my wife and she wants to separate, and she's asking for particular maintenance which you cannot afford to give, now what do you do in these situations is, ओके ओके फाइन देन, तुम इतना भड़कता हुआ वो लिख देते हो लीगल नोटिस कि सामने वाला जो क्लाइंट है तुम्हारा वो तो खुश हो गया, उसको तो समझ में आ गया कि हाँ भाई इसको तो बहुत अच्छी इंग्लिश आती है, इसने तो लिख दिया, तुमने लिख दिया, भड़काते हुए उसकी वाइफ ने जाके 498 ए कर दिया, तुम्हारा जो पर्टिकुलर क्लाइंट है, चलो ही इज नॉट बिहाइंड बार्स, दैट्स अ वेरी आइडियल सिचुएशन इन 498 ए दीज डेज, बट उसकी बेल वेल करानी पड़ गई अब तुमको, तो वो नहीं करना है, दैट्स नॉट व्हाट यू हैव टू डू, यू डोंट हैव टू टेक द अदर लिटिगेंट्स बाय हिज नेक एंड टेल देम कि क्यों किया ऐसा तुमने, नो, you have to be very soft in the whole thing. Now if they have come to you and they're telling you कि ऐसा हुआ है, now my wife is asking for all this property which I have, what do I do now? चुपचाप से buy time for your client now. Okay, because he's already in the deepest of the deepest forest that you can even imagine. Now you have to pick them off. So first you have to locate where your client is. Now how you do that is, you read the prayer in the legal notice, you understand what, now also understand that प्रेयर मतलब PRAYER ऐसे लिख के नीचे उसका पैराग्राफ नहीं होता है, प्रेयर मीन्स व्हाट आर दे आस्किंग फॉर, व्हाट डू दे वांट. Okay, so go to the last paragraph or maybe the second last paragraph, because some fancy advocates don't like writing the prayer as the last. They write a few things like please, please note well, or this is how I write, so a copy of this is attached to with me, kept in my office under safe guidance. Go before that, read it, you'll see. Maybe they're asking for the property, maybe they're asking to dispose of the property, maybe there's something which your client is agreeing to, so ask them, are you agreed to this, do you want to do this, do you want to do this, do you want to do this? Okay, or if it is no, they said no, okay, they said two को no बोला, बाकी को yes बोल दिया, now what to do? Now you have to understand that जिसको no बोला है उसको कैसे deal करना है. Now they said no to the whole thing. Now what do? You write a legal notice saying that we do not face any problem with you, our taste and preferences match, and hence we would like you to come back and live with us. So now what do you do is you open the option for conjugal rights restitution for your client. Okay, you can now file a section 9 for your client, and you can also defend your client there in 498A if in case there's something like that, or maybe domestic violence, or maybe maintenance, or maybe cruelty, maybe desertion, maybe adultery, whatever. So now what you do is you said we wish to live with you and we want you to come and stay with us. So this becomes a base for your case which you're going to file later on if required ever. Now this didn't mean, I'm not trying to say that your client is willing to stay with your with the wife, or maybe the wife with the husband, whichever ways, vice versa. That's not what I'm trying to mean. What I'm trying to say is always safeguard your client first, because that's how you are going to peculiarly take up the whole scenario, safeguard them from all the ends and rounds, and now you can do whatever you wish to. Okay. But in the case which I took up, they had got their legal notice made from some other advocate, and they gave the case to me and one of my friend. Now both of us are sitting there and trying to gauge how do I put the maintenance to bring down the maintenance to this particular place. How do I save my client from not being in a 498A? How do I save my client from not being in DV? DV is domestic violence. How do I reduce everything? Okay, so my friend comes up with a point. Let's find file for section 9. Okay. Now for section 9, okay, fine. हाँ ठीक है section 9. Okay, then I also pestered my friend कि हाँ ठीक है, now we have to do section 9. We have to do section 9. ठीक है, section 9 of the Hindu Marriage Act says that the wife and the husband will come and stay together in the same house. Okay, so no divorce, no cruelty, no desertion, no adultery, no 498A, no DV. My client is happy. I earned money. Done. ठीक है, this is what I was thinking. Until then, I read the legal notice again, which was sent by both the litigators, like the wife's litigator as well as my client's ex-litigator. I read it, and the person in the prayer asks for mutual divorce. So now you admit now you realize what the mistake is. That the ex-litigator admitted that मेरे को तो म्यूचुअल डिवोर्स करना है, मेरे को नहीं रहना है तुम्हारे साथ. Now what will happen is, in the evidence stage of a section 9 case, that particular litigator will take up that legal notice, come in front of the court and say, sir, इन्होंने ही declare किया था that they do not want to stay with my client, and hence that is why I filed this. केस डिस्पोज नहीं होगा, केस डिसमिस होगा, ऊपर से तुम्हें गालियां अलग से पड़ेंगी जज से कि क्या करते हो, थोड़ा तो पढ़ के आना चाहिए. This is what happens. So now what do you do in these situations? You go by book. Then वो जो हुआ है उसी का फाइल करो WS, वही केस कंटेस्ट करते रहो. अब क्या होगा, when both the clients, both the litigants will sit together in the mediation and speak, you will not have an upper hand. Because which you could have had, because you would have said कि हमने तो फाइल किया था, तुम्हें ही हमारे साथ नहीं रहना है. That ways, सब तुम्हें नहीं रहना है, हमें तो रहना है, तुम्हें रहना है, हमें नहीं रहना है. This particular confusion will, what happens is the maintenance comes down. Maybe if she's asking for 10,000, she'll ask for 9,000. She'll ask, अभी ऐसा नहीं होता है कि they ask for 10,000 and they'll come down to 1,000. No. That's another skill where you'll have to, you need to know how you have to put the whole structure, how you have to dress up the mediation, how you have to dress up whatever you're saying. So that skill comes only after 2-3 years of practice. But it's not that I'm saying that abhi se nahi hota hai abhi bhi, but it's not very quick. It doesn't come to you कि हाँ ये कर लेते हैं, हाँ ये कर लेते हैं, because you've not explored so many ideas, you've not explored so many mediations, so you know. So this is how you stop people and restrain people and don't give them good options. Okay. Now, if I'm not that well educated with the whole section, with everything, with the ethos of your litigation, how will that hinder me here is, I'll file the section 9 case. होता है जो देख लेंगे क्या करना है, क्या होगा उसके बाद, dismissal हो जाएगा. You will take that particular piece of paper and you'll be scolded for wasting court's eminent time, which can be utilized in some other dispute resolution, and which you should actually be guilty of. Okay. Now, what after this, if you come down, what particular evidence can you choose to put in at what time? Okay. Now, don't lay all your cards flat open in the first instance itself. Okay. Don't file all your evidence together. File what's required, keep some things for later, and use the card at that time. Okay. So now, if you see that the other places where you have understood what particular litigants have in store for them, you have to understand that not everything which you're thinking of is going to happen the way it's going to come up one by one. Okay. You have to understand which evidence is required at what time. Maybe for a case of maintenance, you have three evidences right in front of you, and you want to file all of them. I've seen people doing this, that they file all the evidences together. Now, what happens in these cases is you spoil it for your client. Okay. They don't require you to come and file everything at one go so that the other litigator is prepared. Now, maybe that litigator is your best of bestest friend, and he knows that, so he knows you through and through. You know them through and through, but still you don't know your client or their client through and through. So you have to be very cautious, and you have to hold back a few evidences at the time, and then file it at the time when it is required. Okay. Now, then you have to understand that this particular evidence's requirement is itna hi. Maybe it's required for only two issues that have been framed, but one evidence gives the answer for all the issues that have been framed. You will not file that evidence right at the beginning. You will file a few evidences first, take your time, let the issues be framed, let them file whatever they have to, then go for your evidence. So this requires you with your particular researching skill, where you know at what flow, at what time, which point has to come up. Okay. So now when you're researching, or maybe many of you will take up LLM after this, you have to understand that your research questions are questions to what answers you will be giving further. But doesn't mean that one question holds all the answers, तो एक बार में सारा ही लिख दिया. नहीं. First you'll write one answer, then you'll write the other, then you'll write the third, then you'll write the fourth, then you'll write the fifth, then you'll give your total findings, then you'll give your survey or whatever. So you should recognize which evidence is, because evidence is actually the very crucial part of it, because without that you are nowhere to go. But it doesn't mean that if you have all the evidence, you can win the you can get the order in the favor of your client. I won't say win the case, but you'll get the order in the favor of your client. So you have to understand that. Okay. Now, education about the subject is what I spoke right before this, where you should know कि कब क्या फाइल करना है और कब कैसे क्या फाइल करना है, जिससे ये पर्टिकुलर चीज इससे मैं बच जाऊंगा या बच जाऊंगी, whatever. ठीक है. What relief you have to get for your particular client is what you are going to do for the rest, one or maybe two or maybe three or maybe 10 years later. So don't go wrong at the first instance. Don't do that. Just gauge whatever you're trying to put forth, then put in one by one. Now, if we move further and we speak of stages in a criminal trial. Okay. Now, what I have seen in the short span of things that I have worked in now is criminal cases are one of those which are so interesting, and it's so good to read all of the material that has come up in criminal matters, is that you get the whole framework so well, and you understand that इसके बाद ये हुआ था तो ये क्यों हुआ था. That step, the flow chart में जो arrow होता है ना, that arrow also has a meaning in criminal trials. Okay. Now, for criminal trial, you have three ways where you can go. One is through the police station where you file the FIR. One is you go through the magistrate, and one is you go to NC. That is 155(2). Okay. Now if you take the peculiar scenario, जैसे तुम्हारे दिमाग में चलता है कि FIR हुआ, अभी इंक्वायरी होगी, फिर अरेस्ट होगा, फिर PCR होगा, 41 का नोटिस होगा, रिकवरी होगी, all of these things, ठीक है. Now if थोड़ा सा भी इससे इधर हो जाता है ना, then you understand, oh my god, what is actually happening. You swept off your feet कि अरे अभी तो अरेस्ट होना था, फिर PCR MCR होना था, अभी ये कैसे हो गया. That is criminal trial. Okay. Criminal trial, you'll always notice people who are in criminal trial, they are always vigilant. Even in their normal scenario also, they're so vigilant and they're so observing that they won't even, they won't leave a step out of here and there. So one of my friend is into criminal trials and I can see he's just like that all the time. He gauges the other person to see that ये criminal ही है, ये कुछ करेगा अभी इधर. So that's how you have to be when you're into court criminal practice. So for that, I would advise people who are vigilant and who know every, have good knowledge about the human anatomy and how a person behaves, where and what they have to do. You're very good and well fit for this particular type of litigation. Okay. So if you only take the peculiar scenario and if you walk through it, you'll see that 154 में you filed the FIR. अभी FIR हुआ. अभी what the police is going to do is what the police is going to do. Leave that. They're going to get the inquiry done. They're going to arrest you. They're going to, not you, sorry, but they're going to arrest. Then they have production of the accused under 57. Then they come for the PCR or MCR whatsoever. And then अगर MCR आ गया, मतलब मैजिस्ट्रेट का कस्टडी मिल गया, then you go for bail, then you go for investigation. फिर डिस्चार्ज होता है, नहीं होता है, वो तो आगे का बात है. ठीक है, what happens further. Because at times you are in the custody, like the person accused is in the custody, but ऐसा कुछ रिपोर्ट आता है which is very ideal. Okay, this only happens in serials कि पकड़ के लेके आ गए, इन्वेस्टिगेशन हो रहा है, अभी इन्वेस्टिगेशन में उसके अगेंस्ट कुछ मिला ही नहीं. This is not how things work. This is very ideal. I don't know why people even think of it like that. ऐसा नहीं होता है. ऐसा बहुत 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 कम उसमें होता है. डिस्चार्ज करके फाइनल रिपोर्ट किया, खत्म हो गया, नोट कंप्लेनेंट को बता दिया, सब एवरीथिंग इज डन. ठीक है. This is very very peculiar. Very peculiar. It doesn't happen like this. Okay. Now if you take the normal scenario, ठीक है, this is one place where the whole flowchart divides into so many parts. Okay, सिविल में ठीक है, 2 हो गया खत्म, उसके बाद हाँ ठीक है, स्टेजेस क्लियर होते हैं. नाउ फॉर कंप्लेंट, अभी क्या हुआ, अरेस्ट एंड प्रोडक्शन ऑफ अक्यूज्ड बिफोर द मैजिस्ट्रेट इज द सेम. इट हैपेंस एवरीवेयर. नाउ इफ सपोज यू गेट द PCR अंडर 167 and then you get the recovery for evidence. अभी you got the recovery, you made the accused get the confession, like the police makes them get whatever confession they have. Confession hua, now the charge sheet will come. Okay, now for before this particular confession, there's again you have to seek MCR also, because you only got your police custody. Now you have to get them into magistrate custody, that is a judicial custody. You go back for the production of accused before the magistrate, then they give you the MCR, then bail, then investigation, and then whatever happens. Now after the investigation is complete, within 60 days ka time mein, they have to file the charge sheet in the court, and then the plea will begin. Now comes the very very interesting part of it, where the plea begins. If the plea is okay, ठीक है, I did murder this person and I want to surrender, तो judgment हो जाता है. But if there is failure, which there is always, and then the particular case is divided into warrant case and summary case. ठीक है, summary में क्या होता है, it is easier for, मतलब summary, I won't say easy, but it's for a shorter duration and things work very easily and then they flow very easily. ठीक है. Substance करते हो आप, charge, not before charge, after charge, substance हो गया. Now there's evidence. Okay, evidence फिर statement पे argument. Evidence मतलब what? If the person is saying, yes, I found them there and they were doing whatever they were doing there, then you get the person, the accused, and say क्या बोलना है इस पे, then they give their statement कि नहीं 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 ऐसा नहीं हुआ था, ऐसा हुआ था, ये वहां नहीं था, ये वहां था. then how do you know? you give your alibi, you were not there. ठीक है, उसके बाद आर्ग्यूमेंट होगा and then judgment होगा. Seems very easy. Okay, it's not. Like, actually I'm telling you, criminal flowcharts are so easy to understand, but they are so difficult when they come up into the normal picture. Now if you have your warrant cases, now understand, summary trials and warrant trials are different. Summary trials में substance of accusation होता है, but warrant cases में you have framing of charges. Like you have framing of issues in civil cases, here you have framing of charges. Now framing of charges, evidence, statement, argument, judgment remains the same. ठीक है, उसके ऊपर का चेंज होता है. अब अगर कन्विक्शन हो गया है प्लीडिंग गिल्टी पे, तो फिर तो क्या ही फर्क पड़ता है, उन्होंने खुद ही प्लीड गिल्टी कर दिया तो क्या है फिर. नाउ फॉर इफ यू से, this is how the police FIR ideal situation will work. Now there will be some other people also who come up and tell you that the police is not taking my FIR, what am I supposed to do now? So you go through the magistrate window, but this window, only the filing window changes, rest जो नीचे होता है वो सब same होता है, everything is the same. So don't get confused when people tell you कि वो प्राइवेट कंप्लेन करना पड़ेगा, बिकॉज दिस इज हाउ आई वाज वेरी कंफ्यूज्ड, बिकॉज आई ओनली थॉट कि ठीक है ऐसे से ऐसे जाते हैं, दे गो टू द पुलिस एंड देन दिस हैपेंस. नहीं हुआ तो देन दे गो टू द एसपी, दे फाइल लेटर्स, व्हाटएवर दे डू, देन दे कम हियर. ओके, सो ऑल दीज थिंग्स आर क्लियर टू यू, but one step here and there and the whole mind will go for a six. Then now if they go to the magistrate orders the police to take up the case, then they go for, again they'll go for 154 back FIR पे. अभी FIR हुआ, वो सारा प्रोसेस शुरू हो जाएगा, अरेस्ट होगा, ठीक है, प्रोडक्शन होगा, प्रोडक्ट किया, फिर PCR मिला, MCR मिला, जो भी मिला, and you either have to get a negative report out of it because you did the inquiry, you thought, you got to know, you didn't think, you got to know कि accused का तो कुछ लेना देना ही नहीं है इससे, they were not even present there. So there's this one movie where they speak of कि हम वहां गए थे, सत्यनारायण की कथा थी, वो सुनी, उसके बाद हम यहाँ आ गए. Okay, I can't, okay, Drishyam, yeah, right. So that's the movie and you say that, okay, अभी ऐसा सच में किधर तो हो गया, and they were actually not present there and they have full evidence of, they have eyewitness, they have the tickets to show you, they have everything to show you, they're very they were not actually there. So that's where you will file the police files a negative report. Okay, fine, negative report हुआ, फिर then you get the complainant, you examine the complainant. भाई तूने तो ये बोला था, ये हुआ है, now what do I do? The complainant will tell you, then they'll help you कि नहीं ऐसा नहीं, ये हो रहा था, this ticket is real, this ticket is false, this is right, this is wrong. They'll ask you, you'll tell them. So all these things will come back to zero. Okay, कि फिर से ढूंढो अभी, this ticket is false, then look for the real ticket, were they really there, let's go to that place and check out. So this is part of investigation. So this is all that the police will be doing. What your gameplay is, once the case, the trial begins, summary trial हो रहा है, warrant trial हो रहा है, discharge हो रहा है, क्या हो रहा है, all that is your point. Even if your client tells you that they want to plead guilty or they want to discharge the acquittal or whatever the thing is, it's on you, you only know what has to be done. ठीक है. Now this is how the criminal trial will begin. Now always understand that when I say that a criminal trial person who is into core criminal litigation is very observant, doesn't mean that I'm saying that a civil litigator is not observant. They might be way more observant than that, but that's what they like to do. So they're doing it that way. So it doesn't mean that if you are into civil litigation, you don't have to be observant. You have to be observant even then, because that's where your education plays a role. But civil technically goes by the book, whereas criminal trials don't go by the book. they have lot of other options. The flow chart is divided into three at the first place itself. At least for the civil trials, civil suits, you don't have to, the flowchart doesn't divide at the initial edge of it. they are they divide further, they have branches, they do it, but in the beginning it's filing of the case. So that this is how it will work. Now I have to put in my things कि क्या करना है. ठीक है. Now when you move ahead and you realize that ठीक है चलो केस तो हम कर लेंगे, but what is your homework? Like I was telling you that the previous homework helps you with your classwork on that final day. Now the previous homework is, first when the person is coming to you, you have to understand what kind of a judgment and what kind of a relief that can I get him or her. ठीक है, on your own. Now you have to understand कि ठीक है इसके पास सब पेपर सब कुछ है, but you don't know what the other litigant is going to get, and that is where you're taken by surprise. अरे ये तो मैंने सोचा ही नहीं था. So that is where you have to think that the branches can go in any and every place. Okay. Now for criminal, once everything is done, these are the evidences, this is how the court is going to decide. But for civil, anything can happen anywhere. You don't know what's going to happen when, which evidence is going to come up when, because just like you are thinking कि ये evidence मेरे को अभी नहीं डालना है, you have to also think that the other litigant is also thinking like that कि ये evidence अभी नहीं डालना है. So they might be waiting for the correct time at that place कि इस time पे हम करेंगे, इस time पे हम नहीं करना चाहते हैं. So that's how things work for both the places, not only one. Now once you've created your judgment on your own, that is only possible with experience, with you reading few judgments, with you reading books, with you reading your research papers, with you reading the section easily, with you knowing what subclause, what clause is there, what other things you can explore, what they can explore, what they might have explored. So it's very important for you to have good books with you. And by that I'm not saying just buy the bare act for the subject and you're done. No, you need textbooks when you're in your law school. You need them because you will actually need them later on if you're in litigation. Because if you see the corporate structure, you need books only for certain subjects, but here if you want to shift from one litigation to the other, you will have to read from scratch. You will have to do it from scratch. Now if suppose you're into core civil practice and a good murder evidence comes into your hand and the person tells you that please take up my case, what are you going to say? You're going to say no, I won't take it. Why are you shutting down your shop for yourself? So you will take that thing up. Okay, so for that you have to read CRPC नीचे से पूरा and then go up to the next thing and understand how a criminal trial will work. Okay, and by just saying CRPC, I don't mean that you don't need CPC or IPC. You need everything. For both the structures, you need everything. For civil, you need it. For IPC, for criminal, you need it. For IP, you need it. For commercial litigation, you need it. Because now you'll tell me 420 and 406 cheating for a particular structure where only commercial goods are at your strata. You will say that this is not criminal, this is commercial. So that's how criminal and commercial are linked. That's how family links with IPC in 498 or maybe CRPC in 498A or adultery, which was, but now we don't have adultery in IPC. It's not anymore an offense there. So now you have to understand that whatever research you're doing, it's all connected to each other. You have to get this into your system that once maybe you're in the cyber strata of litigation. Okay, the genre is cyber. Okay, you began with cyber practice, एकदम से CRPC IPC आ गया. Now you're swept off your feet. What do I do? Your mind goes for a 6 and you say कि अभी क्या करना है. Now you have to understand that both of these things are linked. So one subject clarity is not going to help you in one litigation. You have to have other subjects ka hold also. Because at times you might file a case where you only filed for a few sections because you weren't even aware of the other sections at your disposal. Okay, you were not aware of other sections like maybe 354A, which you could do for a women to get relief. Okay, so that's how things will fall into place if you know, and if you go by books, and if you have read books, and if you have read textbooks. So that's how I tell you that a textbook will offer a lot of other interpretations of the same section, whereas a bare act will only tell you what the section reads. Okay, so bare act comes later. First, it's the textbook. You have to read the textbook first if you are planning for litigation. I'm not saying that the other places will not require textbook and in depth knowledge, they will also require in depth knowledge. But for litigation, all your life you will require that textbook, because you need to know and focus on the interpretation of that particular section, because the way you are interpreting it might not be the way the other litigator is interpreting it. So you have to explore, because see, not all the times you will know what the other litigator is thinking. If the person is my friend and I have studied with them and I know what their flow chart is, but and still I cannot tell you that that person is going to particularly act in this way, because they have so many things in their disposal to use at that time that they won't use only one thing for relief to their client. Okay, now, other than this, what's going to help you very well is the case laws which are happening in recent times, not MC Mehta versus Union of India. Okay, that's one thing. Stop using now until very well required. And if you don't know anything other than that, use MC Mehta versus Union of India. But stop using MC Mehta versus Union of India. Okay, there are other things that have been come up, and there are other things that have come up in the latter part of last year, where we also thought that this particular thing will get an order for in favor but didn't. For example, the same sex marriage, you thought कि हो जाएगा, but then things came up, वो नहीं हो रहा है. So you should know not everything will work as per your mindset. There are a lot of people who are involved in one case disposal. There is a clerk, there is a JMFC judge, or there will be ADJ, PDJ, High Court, whatever. Okay, so there are many people involved. The other court staff is also there. You are there. Your client is there. The other litigator, the other litigant. There are a lot of people involved in just one thing. So you should know that the all the ideas which you have, they also have the same, but you're just using it the other way. So you should know all the other ways that you can use it, so you don't make a mistake so heinous and but so petty like a section 9 filing which I had to go through. So you should always understand that what particular facts and facets you have in store for yourself. So that will also come up if you are reading well the case laws which are coming up, because what has happened today and what will happen tomorrow can be predicted by what happened in the past, in litigation at least. Okay, so if you are in the framework ki, chalo, I'll read this today and I'll read this genre today and I'll understand what happened in this case. Okay, I agree that you won't get the in-depths of it, and you'll only get what order sheet is there, what order sheet is available there, what evidences का भी थोड़ा झलक मिलेगा in the order sheet itself. But at least you'll know that there's this facet also which is yet to be explored by you. So you will understand that there's commercial litigation, and then there is another litigation which is called consumer protection, and then there's other litigation that is called NI Act. So you, not everything will be taught to you by a senior. Some things you'll have to read on your own and then decipher that this particular genre is also available for me to practice and to use. So that's where you'll read, and God forbid one day you get something like that, and then, oh, I read this citation there, and let's take out the book and then read it. No, that's not going to happen. The person has come to you, they seek immediate relief. Although litigation में कभी भी immediate relief नहीं होता है, but they come to you seeking immediate relief, and you chose this profession for yourself, so you have to explore all the facets that is available for you. So if you read that citation that day, and if you had read those sections on the same day itself, what would have been in your favor today? कि आपको पता होता कि इसको कैसे आगे लीड करना है, इसको किधर फाइल करना है. Because some people, they don't know yet, even after so many years of practice, and I'm telling you this, that they don't know where to file what. People don't know that the consumer protection is to be filed in the consumer redressal forum and not in the civil court. So this is a very basic but the biggest blunder you'll ever make, where you don't know where to file what. So I understand that the procedures of the cases of the courts are different in different states, but even if if the district changes, the procedures change for a little, because the people acting there are different. It's not that your judiciary is changing things. It's just that apni convenience se people have crafted a few ways where they can function easily and without giving the other person a little stress. Because if I'm practicing it currently in two places where I've seen this very peculiar difference. Okay, where we file an attendance before the court through written submission. Okay, but in the other place they file the attendance in oral submission. So that's not very different, but it's different because the thing is that the judges might have assumed, the court staff might have assumed कि हम इतना कर सकते हैं कि ये आएंगे, हम उस टाइम अटेंडेंस ले लेंगे. Because it's actually a pressure on them, because whenever the person is going to come, they'll have to again you open their e-code system, mark their attendance, or maybe the sheet of paper, mark them. So it's inconvenient. So this court said that ऐसे नहीं करेंगे, but this court said that we'll choose this sector. So that is where you lack if you're not practicing in that place for a regular 6 months. So you need to know the procedures of the place so that you are easier on your client, and you don't have to call him each time कि अरे आओ आओ आज date है. क्यों है? You do that. If that person is not required there, why will you call them? Just to look at the face or look at each other and say, oh भाई कैसा है? You have a lot of time to do that in the evening. Don't do it with them because it's the peak hour when you're in court. It's 11 to 2. That's the peak for the court. Like I am not saying that 2 बजे के बाद काम बंद हो जाता है, होता है काम, but 11 to 2 is very okay. The session is going to be for 1 hour. If you have a problem with it getting elongated, you can leave, but I have a few things to cover and then I'll just wrap it up. So you have to take it as not coming in for at the same time, and the procedure should not elongate for you and for the client. So don't call them at the peak hour, and don't tell them to leave their office and come in, just for an attendance filing. Okay. Now, the other ethos which you should know are 3. That is logical, credibility, and emotional. So if you are not logical towards your approach, and if you are not credible, like if you're not very well educated about the subject, and if you don't know how things work in that particular subject, then nothing is going to work for you. Because one day or the other you will be caught on the wrong foot, you won't get relief to your litigant, and everything will be gone for you. And the other part is emotional. Whatever emotional investment you do towards that case to get relief for your litigant is what you can do, as what works like magic for you. If you're not personally invested, if you're not personally involved, then logic won't work, credibility won't work. You will be upper se in the case. Okay, so you have to be, little emotional involvement is required. Not that it's giving you trauma or your family trauma, but you have to be little emotionally involved and not carry the baggage home. Okay, so rest is last one bit, that if you're taking up litigation, get a few subscriptions, not the expensive one. I'm not telling you to take Manupatra or SEC online or something which might go out of your budget, but take something like Live Law and pitch in with a friend. Take it for half and read, because reading is going to help you for not only for litigation but for other things also. So researching, reading, these are the pillars of litigation and the roadmap to your success. So This is what I have for today, and I would take up any interactions which you require. So let me know if you have any questions. Okay, so I assume people do not have questions, and I was very good at it, and that's how I'll take it. Okay, so and if not, I would assume that I'm the best at eloquence, and I'm a very
Ma'am,
good orator. Yeah,
ma'am,
tell
I have
me. Yes, yes,
one
yes.
question, ma'am. Ma'am, what is the difference between FIR and complaint, ma'am?
Okay, see, there's no difference between an FIR and a complaint, because an FIR is a complaint. Okay, like the private complaint which you do is when the police is not ready to take up your particular whatever complaint you have, maybe for a small thing like a theft. Okay, so it's a
Yes,
1 lakh
ma'am.
rupees theft from your Almira, and the person could not file the complaint in before the police because they're not taking it, or maybe for whatever reason. So you go through the magistrate. So there is no
Yes,
difference. Both are complaints, but just the window of it changes.
yes, ma'am.
Is it clear?
Yes, ma'am. Yes, ma'am.
Okay.
Thank you, ma'am.
Anything
Thank you.
else? Most welcome. Most welcome.
Good afternoon, ma'am.
Yes.
Ma'am, this is Arghya Patnaik, second year Kids School of Law. My question to you is, although I'll be a second generation lawyer, still I'm often discouraged to go into the field of litigation because, as we all know, the initial years are not going to be that easy. There would be no stable income. We'll be handling the files under our seniors and many more hurdles like this. So, what is your breakthrough in that situation? Like, do we have to wait for our independent practice, or can we just have any other source of income?
Okay, very well crafted question. I would say you are a second generation litigator, and I can see that in your question. Very nice question, and I'd say, and I wanted to speak about this also, but there's constraints of time. See, you won't have a stable income, this is for sure. Okay. You will be at the mercy of your senior on what he gives you on or what she gives you for that particular day, and you're done. Okay. If you are a first generation advocate, then it's difficult for you even more because the exposure which you get is a little limited, because you are at the mercy of your senior. उसने तुमको फाइल दिया पढ़ने को, तुम पढ़ोगे. But if you are in the office of maybe your uncle or maybe your father, then you get the exposure for files. At least you can read more than the other things. Okay, so other stable income if you want is through, there are many sites which, if you like teaching, okay, if you can teach, then you can write research papers for them, edit their blogs, make their lectures, okay, write their books. So that's where you'll get good handsome amount like 30-40,000 you can make. Or then if you settle down for 6-8 months and you realize how practice is going, then you can get into arbitration of international clients, okay, who you can represent through your particular portal. So that's how we are also working on. So these are two ways which you can earn good handsome amount into your pocket and also practice litigation at the same time. So if you're a second gen, I would encourage that you take up litigation, because there's nothing like litigation and you'll enjoy being here. But also you will have to take up other facets which come along with litigation. That is, first 5 years at least you don't have good stable income. Okay, and if you're smart at it and you know where and what to get from, then you'll manage out your own ways, and you will know that this is how you can get into it. Then you'll take up arbitration, then you'll take up mediation, you'll take up small agreements here and there, make contracts for them. The miscellaneous pre-litigation will be good for you. Am I clear to you, or do you have any doubt even further?
No, no, ma'am. Thank you so much.
Okay, any other doubt, you guys?
Ma'am, I have one question,
Yes.
ma'am.
Yes.
When we can file, ma'am, zero FIR, ma'am?
Where you can file zero FIR.
Yeah, ma'am.
Okay. So, मान लो you are traveling from a place to the from A to B. Okay. Now A to B. You are in which year, Salman? Tell me.
Ma'am, second student, ma'am.
Okay, you are in second year. Okay,
Yes,
then this is a question which I also had when I was in second year. Okay, you're traveling from A to B. Okay,
yes,
something happened रास्ते में which is maybe A.2. A.2 में कुछ हुआ. Now the jurisdiction in that place is not for A also, not for B also. So
yes,
you'll
ma'am.
go to B, then you'll come back to A. Now
Yes, ma'am.
you won't stop in A.2 and look for a police station here and there कि कहाँ
Yes,
जाके file करूँ कहाँ. So you
yes,
stop there, you see whatever has happened, whatever evidence you can collect from there, you go to B, file in zero FIR there. So the jurisdiction is the idea. When you're filing a zero FIR, it's the jurisdiction. Okay.
yes, ma'am.
Anything else? I'm open to questions. You can ask whatever you wish to. Only oriented to law. Nothing out of that. Okay, so I suppose you don't have any questions, and I was a very good orator and I helped you solve all your questions. So, Sanskriti, tell me anything else? Thank you to Legal Guardian, and thank you for everybody else who came up and. Sorry for taking so much time of yours, and I I didn't think I don't think litigation का कोई भी session can only be wrapped up in 1 hour. It takes a lot of time to explain both the facets, and I'm sorry if I took a lot of time. And welcome everybody who's putting in thank you there. And I hope you guys enjoyed. And one piece of advice: please be very attentive in your classes, and if not in your classes, marks don't matter. Just know what you're doing, where you are, and what you are there for. Okay, even if you're there for attendance, do it. And rest, everything else is that you should be very focused with your extracurricular activities also. Just don't keep reading and researching and getting marks. Okay, that's not going to help you. Do something apart from that also. Go participate in moot court competitions and take up research scenarios, attend research scenarios, and take up sessions, attend sessions, and do whatever you can do apart from books, reading, बैरक, textbook. ठीक है, इसके अलावा भी बहुत सारी चीजें हैं. Okay, so thank you so much, and all the best to each one who's present here, and thank you for having so much patience and listening to me. Thank you. Thank you. Okay.